In his ruling on Monday, U.S. District Judge James Boasberg wrote that a group of Venezuelan men deported to the infamous CCOT prison in El Salvador were denied their due process rights and will thus require the government to facilitate their ability to obtain such hearing. Our law requires no less. He added, plaintiffs should not have been removed in the manner that they were, with virtually no notice and no opportunity to contest the basis of their removal. The Trump administration has not said if it will appeal yet. Those deportations came after President Trump invoked the Alien Enemies Act, a rarely used law that allows the removal of non-citizens with little to no due process. The prison is notorious for its harsh conditions. A New York Times investigation in November published accounts from prisoners who said they were subjected to physical violence and sexual assaults at the hands of prison guards. It was also the subject of a 60-minute segment set to air this past weekend. But according to a CBS News statement, it was pulled from the episode because it needed additional reporting. However, on Monday, that segment did appear in a version of 60 Minutes that streamed on the Canadian Global TV's digital platform in Canada, quickly spreading across social media. The report shared the story of at least one man who recounted being forced into stress positions under the threat of solitary confinement in a windowless, pitch-black room. CBS News said it plans to air the Inside CCOT 60 Minutes segment in a future broadcast.
Something remarkable is happening in federal courtrooms across the country. Judges are blocking Trump administration immigration policies, not with gentle suggestions or polite recommendations, but with emergency orders, contempt findings, and injunctions that have actual teeth. They're ordering the immediate release of people unlawfully detained. They're certifying nationwide classes that could affect tens of thousands. They're requiring DHS to document every single warrantless arrest going forward. They're holding the government in contempt for defying earlier orders. And they're doing it fast, issuing temporary restraining orders within 48 hours, sometimes within hours. This isn't the judiciary of Trump's first term, when courts were still calibrating how to respond to executive overreach. These judges have seen this playbook before. They know the administration will ignore orders if there are no consequences. So they're imposing consequences. In Maryland, Judge Paula Zenas ordered a man released from ICE custody, and when the government tried an end run by having an immigration judge create a removal order the same night, she granted an emergency restraining order at 7:30 the next morning, blocking redetention. In D.C., Judge Beryl Howell blocked warrantless immigration arrests and ordered DHS to document the factual basis for every arrest going forward, creating a paper trail, making them show their work. In California, Judge Sunshine Sykes certified a nationwide class of tens of thousands of people who are entitled to bond hearings under a mandatory detention policy that violates 3 decades of established law. In Northern California, Judge Casey Pitts blocked courthouse arrests in a 67-page opinion, finding the redetention policy arbitrary and capricious. And on December 20th, the Supreme Court, the conservative supermajority Supreme Court, denied the Trump administration's emergency appeal in an immigration judge's free speech case. The first time Trump has lost on the emergency docket in 11 months. This is the federal judiciary using its full constitutional authority to enforce the rule of law against executive lawlessness, not deferring to immigration plenary power, not treating court orders as suggestions, but forcing compliance through contempt powers, mandated releases, discovery obligations, and preliminary injunctions that stop policies in their tracks. Let's decode what's happening, why judges are responding more aggressively than in Trump's first term, and what it means for the broader fight against authoritarianism. Let me tell you a story that illustrates exactly what we're talking about. Pilmar Abrego Garcia is a Salvadoran citizen living in Maryland with his U.S. wife and child. In 2019, an immigration judge granted him protection from deportation, found he had a well-founded fear of gang persecution in El Salvador. He was allowed to live and work in the United States under ICE supervision, though he didn't have permanent residency status. In March 2025, DHS deported him to El Salvador anyway, despite the 2019 court order barring his deportation. They falsely claimed he was an MS-13 gang member. He denies it. And he ended up in CCOT, El Salvador's notorious mega prison, with no criminal record. In June, they brought him back to the US to face human smuggling charges in Tennessee. He pleaded not guilty. He was released to his brother's custody pending trial. In August, during a routine ICE check-in, they detained him again, held him in a Pennsylvania detention center. On December 11th, Judge Paula Zenas ordered his immediate release. She found the detention troubling and without lawful authority. She wrote, "Since Abrego Garcia's wrongful detention in El Salvador, he has been redetained, again without lawful authority. His removal cannot be considered reasonably foreseeable, imminent, or consistent with due process. There was no valid removal order. The government was just holding him. And here's where it gets interesting. Hours after Judge Zenas ordered his release, an immigration judge, Philip Taylor, issued a decision claiming the 2019 order erroneously omitted a removal order. They tried to retroactively create a legal basis for his detention. Abrego Garcia's attorneys filed an emergency motion at midnight. At 7:30 the next morning, December 12th, Judge Zenas granted the emergency restraining order blocking redetention. Abrego Garcia went to his scheduled ICE check-in. He wasn't arrested. He walked out to cheers from supporters and said, "Stand tall against injustices." His attorney, Simon Sandoval Moshenberg, called it a victory of law over power. And Judge Zenas didn't stop there. She documented a pattern of government misconduct. DHS claimed Costa Rica was unwilling to take Abrego Garcia, but Costa Rica publicly stated their offer to accept him was firm, unwavering, unconditional. The government lied. DHS threatened to deport him to Uganda, Eswatini, Ghana, Liberia, countries that never agreed to take him. The government was making things up. They refused to deport him to the only country he's agreed to go, Costa Rica, because, as Judge Zenas noted, whatever purpose was behind his detention, it was not for the basic purpose of timely third country removal. Translation: they're not detaining him for deportation. They're detaining him as punishment for challenging his removal, for having a lawyer, for winning in court, and Judge Zenas isn't having it. She ordered that the government must give 72 hours written notice before deporting him to any country. She's supervising them, like you supervise a child who keeps lying. DHS's response? Spokesperson Tricia McLaughlin: "This is naked judicial activism by an Obama-appointed judge. This order lacks any valid legal basis, and we will continue to fight this tooth and nail in the courts." Notice, they didn't cite legal authority. They didn't explain their reasoning. They attacked the judge's appointing president. That's what you do when you can't defend your actions on the law. Now, let's talk about Judge Beryl Howell's December 3rd ruling in Washington, D.C. DHS had adopted a policy allowing warrantless civil immigration arrests based on reasonable suspicion that someone is deportable. But federal statute, 8 U.S.C. Section 1357A2, requires probable cause that the individual is likely to escape before a warrant can be obtained. That's not a small distinction. Reasonable suspicion is a lower standard. It's what police need to stop you on the street. Probable cause is a higher standard, what they need for an arrest warrant, and the statute says probable cause, not of deportability, of escape risk. But DHS decided reasonable suspicion was good enough. Border Patrol Commander Gregory Bovino said so publicly. Judge Howell issued an 88-page opinion blocking the practice. She granted provisional class certification for everyone arrested in D.C. without proper escape risk assessments. and she found that ICE agents were patrolling neighborhoods with large numbers of Latino immigrants and stopping people indiscriminately, setting up checkpoints in Latino neighborhoods without individualized suspicion. That's racial profiling. That's Fourth Amendment violations. So Judge Howell didn't just block the policy, she ordered DHS to transmit her order to every federal agent with immigration enforcement authority. She ordered them to document the factual basis for each warrantless arrest going forward. She's creating a paper trail, making them show their work, building a record for future constitutional challenges. This is a judge who knows that general orders get ignored. So she's imposing specific, enforceable requirements with consequences. And it's working. Because now there's a record. If DHS continues warrantless arrests without probable cause, they're violating a court order. That's contempt. That has consequences. Now let's talk about scale. On November 18th, Judge Sunshine Sykes in California's Central District certified a nationwide class of non-citizens subject to the Trump administration's July 2025 mandatory detention policy. Here's what that policy did. DHS issued a memo reinterpreting the Immigration and Nationality Act to classify virtually all undocumented immigrants as applicants for admission subject to mandatory detention. For 30 years, that provision applied only to recent border crossers, people trying to enter the country. But the new interpretation extends it to anyone present in the U.S. illegally, even people who've been here for decades, with families, with businesses, pursuing legal status. Judge Sykes said, it is unambiguous that applicants for admission do not include non-citizens already in the United States. And she didn't just rule for the individual plaintiffs. She certified a nationwide class, meaning tens of thousands of detained immigrants are potentially eligible for bond hearings and release. That's not one person walking free. That's a systemic challenge to the administration's entire detention infrastructure. ACLU senior staff attorney Maikon No explained, these are neighbors. These are people who've been in the community for decades, have had jobs, have built families here. They were always, until July 2025, classified as under discretionary detention, meaning they were entitled to bond hearings, to argue they're not flight risks or dangers to the community, to be released while their cases proceed. The Trump administration stripped that right through an internal memo. No notice and comment rulemaking, no public process, just a policy change that allowed indefinite detention without hearings. And Judge Sykes said no. That violates the Administrative Procedure Act. It violates due process. It's unlawful. DHS claimed the policy was a big win, securing our ability to detain illegal aliens until they are deported. But Judge Sykes recognized what it actually was, stripping people of due process to make deportations faster and easier. And the court isn't allowing it. On December 20th, the same day the Supreme Court rejected Trump's emergency appeal, Judge Casey Pitts in Northern California issued a 67-page order blocking DHS from rearresting people at courthouses and routine check-ins. Here's what was happening. Starting in May 2025, DHS officers began rearresting and redetaining people whom DHS had previously released. Not people who'd violated conditions. Not people who'd committed new crimes. Just people the government had already determined could be safely released, and then changed their minds. Judge Pitts found this violated due process. The government was detaining people without first making individualized determination that individuals' material circumstances had changed, such that they posed flight or security risk. And DHS provided no written explanation for the new practice. No policy memo, no guidance, nothing. Judge Pitts wrote, there is no evidence in the record that DHS offered a reasoned explanation for its changed approach. The natural conclusion is that no contemporaneous rationale existed. This alone makes the redetention policy arbitrary and capricious. Translation: they just started grabbing people. No reason, no process, no explanation. That's not law enforcement. That's arbitrary detention. So Judge Pitts paused the redetention policy across Northern California and the Pacific Islands until final judgment, which is expected in the coming months. Hundreds of people had been arrested at routine check-ins since May. People showing up voluntarily, complying with their release conditions, doing exactly what the government told them to do, and getting arrested for it. The judge found that causes irreparable harm, deprivation of physical liberty, and deprivation of constitutional rights. And she stopped it. Now let's talk about December 20th's other major development. The Supreme Court rejected the Trump administration's emergency request to halt a lawsuit over immigration judges' free speech restrictions. Trump's DOJ requires immigration judges, who are DOJ employees, not independent judges, to obtain prior approval for any public speeches about their work. The National Association of Immigration Judges sued, claiming that's a First Amendment violation. The administration wanted the case heard by the Merit Systems Protection Board instead of federal court. But here's the problem. Trump has gutted the MSPB. He fired members, left it without a quorum, eliminated the U.S. Special Counsel Office that protects whistleblowers. So the administration's argument was essentially, don't let a federal court hear this case. Send it to an agency we've destroyed that can't function. The Supreme Court said no. At this stage, the government has not demonstrated that it will suffer irreparable harm without a stay. They let the district court proceed. This is significant for two reasons. First, it's Trump's first loss on the Supreme Court's emergency docket in 11 months. His administration has filed 32 emergency applications since January 20th. The court sided with them about 24 times. This is the first rejection. Second, it signals that even the conservative supermajority has limits. Even they won't let the administration completely avoid judicial review by routing cases to agencies they've deliberately broken. The court left the door open for the administration to return with a subsequent emergency appeal if discovery begins. But for now, the judges can move forward with their First Amendment challenge. And that matters because over 100 immigration judges have been fired, reassigned, or pushed out under Trump, out of only about 700 total. Trump is hiring deportation judges with an enforcement first mandate. Judges are being pressured to complete cases faster and deny more claims. If judges can't speak publicly about due process violations, those abuses stay hidden. The Supreme Court's decision preserves their ability to blow the whistle. Here's what's critical to understand. This isn't one activist judge in one jurisdiction making one controversial ruling. This is judges across multiple districts: Maryland, D.C., California, Central, Northern, and Eastern districts, reaching the same conclusions based on the same constitutional principles. Judge Sinus, Obama appointee; Judge Howell, Obama appointee; Judge Sykes, Obama appointee; Judge Pitts, Biden appointee; Judge Nunley in Eastern California, Obama appointee. But they're not just Democrats. Judge Howell is actually a Bush appointee to the district court, who was later elevated. And the Supreme Court's December 20th order had no noted dissents, meaning even the conservative justices didn't publicly object. The legal reasoning is consistent across these cases. Indefinite detention without a hearing violates due process. Warrantless arrests without probable cause violate statute and the Fourth Amendment. Changing 30-year-old policies without notice and comment rulemaking violates the Administrative Procedure Act. Redetaining people without individualized assessment is arbitrary and capricious. These aren't novel legal theories. They're bedrock constitutional principles and administrative law requirements that the Trump administration is violating. And when DHS can't defend their actions on the law, when they can't cite statutory authority or explain their reasoning, they attack the judges instead. Naked judicial activism by an Obama-appointed judge. That's what you say when you've got nothing else. So why are judges responding more aggressively now than during Trump's first term? Because they've learned. In 2017 and 2018, courts were still calibrating. They were trying to balance deference to executive authority with constitutional limits. They were issuing narrow rulings, giving the administration chances to comply, assuming good faith. And the administration exploited that. They ignored orders. They found workarounds. They slow-walked compliance and dared judges to do something about it. So now, judges are doing something about it. They're issuing emergency restraining orders within hours, not weeks. They're certifying nationwide classes instead of ruling only for individual plaintiffs. They're requiring specific documentation and creating paper trails. They're finding contempt when orders are defied. They're writing detailed opinions, documenting patterns of misconduct. Judge Zenas didn't just order Abrego Garcia released. She required 72 hours written notice before any deportation. She's supervising the government like a probation officer. Judge Howell didn't just block warrantless arrests. She required DHS to document every arrest and transmit her order to every agent. Judge Pitts didn't just rule the redetention policy was unlawful. She issued a 67-page opinion explaining exactly why, creating precedent for future cases. These are judges who know that polite suggestions get ignored, so they're imposing enforceable orders with consequences. And it's working because they have the tools to enforce compliance: contempt powers, discovery obligations, the ability to order immediate release through habeas corpus petitions. The Trump administration can appeal. They can try to get stays, but in the meantime, people are walking free. Policies are being blocked. The deportation machine is being slowed by judicial friction. That's not everything, but it's not nothing. Let's talk about what these judges are actually protecting. Habeas corpus, the fundamental protection against arbitrary detention. It dates back to the Magna Carta. It's in the Constitution. It means the government has to justify why they're holding you, and a judge gets to review that justification. Without habeas corpus, the government can just disappear people. No hearing, no review, no accountability. Due process. The Fifth Amendment says the government can't deprive anyone of life, liberty, or property without due process of law. That applies to everyone in the United States, regardless of immigration status. Due process means you get notice, you get a hearing, you get to present evidence and make arguments. The government has to follow established procedures. The Trump administration is trying to eliminate due process for immigrants: indefinite detention without hearings, expedited removals without review, redetention without explanation, and judges are saying no. The Constitution applies. Fourth Amendment, protection against unreasonable searches and seizures. You can't be stopped, searched, or arrested without probable cause, and usually a warrant. DHS is conducting warrantless arrests based on reasonable suspicion, a lower standard, and doing it in ways that look a lot like racial profiling. Patrolling Latino neighborhoods, stopping people based on appearance, language, or location. That's unconstitutional, and judges are blocking it. Administrative Procedure Act. When agencies want to change major policies, they have to go through notice and comment rulemaking, publish proposed rules, accept public comment, justify their decisions with evidence and reasoning. The Trump administration is changing decades of immigration policy through internal memos. No public process, no opportunity for input, no reasoned explanation. That violates the APA, and courts are striking those policies down. These aren't abstract principles. They're the infrastructure that prevents authoritarianism. They're the limits that keep government power in check. And the Trump administration is trying to eliminate them for immigrants first, but with implications for everyone. Because if the government can detain immigrants indefinitely without hearings, What stops them from doing it to citizens? If they can ignore the Administrative Procedure Act for immigration policy, what stops them from ignoring it for everything else? Once constitutional limits erode, they're very hard to restore. Every court order has immediate material consequences. Tilmar Abrego Garcia is home with his wife and child instead of detained in Pennsylvania or deported to a Salvadoran prison. Tens of thousands of people detained under the mandatory detention policy are now eligible for bond hearings, a chance to argue for release while their cases proceed. People in DC can't be arrested based solely on being Latino in a Latino neighborhood. People in Northern California can go to routine check-ins without fear of being grabbed and re-detained for no reason. These are real people, real families, real lives affected by whether courts enforce constitutional limits or defer to executive overreach. And beyond the individual cases, these orders create systemic barriers to Trump's mass deportation agenda. Every injunction slows the deportation pipeline. Every bond hearing means someone gets released instead of held indefinitely. And people with attorneys living in their communities are much harder to deport than people locked up in detention. Every discovery obligation exposes government misconduct. Every documented pattern of lying to courts or ignoring orders creates evidence for future accountability. Every precedent constrains not just this administration, but future ones. That's the long game. Not stopping every deportation, but creating legal infrastructure that preserves constitutional limits, forces transparency, and makes authoritarian governance harder to implement. Let's talk about how the Trump administration and its defenders are framing these rulings. Activist judges blocking enforcement. They focus on the judges appointing presidents, Obama judge, Clinton judge, as if that explains the rulings, as if constitutional analysis is just partisan politics in robes. But multiple judges, appointed by different presidents, are reaching the same conclusions, because the legal reasoning is sound. The administration is violating statutes, the Constitution, and the Administrative Procedure Act. When DHS spokesperson says naked judicial activism, she's not citing legal authority. She's not explaining why the judge got it wrong. She's attacking the judge's legitimacy to avoid defending the policy on the merits. That's what authoritarians do. Delegitimize institutions that constrain power. Plenary power means courts can't review immigration. This is a shell game. Plenary power means Congress has broad authority to set immigration policy, visa categories, admission criteria, numerical limits, and the president has enforcement authority. But plenary power doesn't mean the Constitution doesn't apply. It doesn't mean the president can violate statutes, ignore the Administrative Procedure Act, detain people indefinitely without hearings, or conduct warrantless arrests without probable cause. The Supreme Court has never said immigration enforcement is exempt from constitutional review. Even at the height of the plenary power doctrine, courts reviewed detention conditions, access to counsel, procedural fairness. The administration is trying to turn plenary power into unlimited executive authority. And courts are saying, no, that's not what it means. These are dangerous criminals. They cherry-pick individual cases like falsely claiming Abrego Garcia is MS-13 to imply everyone detained is a violent criminal. But the policies being challenged apply to everyone. People who've been in the US for decades, people with families and jobs, people with no criminal record. The mandatory detention policy doesn't distinguish between someone convicted of a violent crime and someone who overstayed a visa 20 years ago and has been a model resident ever since. And due process protects everyone. The whole point is that the government has to prove someone is dangerous or a flight risk before detaining them indefinitely. You don't eliminate due process just because some subset of people might be dangerous. That's punishing everyone for the actions of a few. Due process is just delays and loopholes. This is the most insidious framing, treating constitutional rights as obstacles, as if speed of deportation is more important than accuracy. But wrongful deportations happen. Abrego Garcia was deported despite a court order protecting him. People get deported to countries they've never been to, or where they face persecution, or where they have no family or connections. Due process exists because the government makes mistakes, because bureaucracies cut corners, because agents lie. Bond hearings, access to counsel, judicial review, these aren't loopholes. They're safeguards. They're what prevent people like Abrego Garcia from ending up in El Salvador's CCOT prison when they have valid claims to protection. And when the administration calls constitutional rights delays and technicalities, they're revealing their priorities: speed and cruelty over justice and accuracy. Here's the structural reason this is working. Federal judges have lifetime appointments. They can't be fired for ruling against the president. Their salaries are constitutionally protected, can't be reduced as retaliation. This is working exactly as the founders designed. They created an independent judiciary precisely to check executive overreach, to protect individual rights against majority tyranny and government abuse. And it only works if judges use their power, if they defer reflexively to executive authority, if they treat court orders as suggestions, if they avoid imposing consequences when orders are defied. Then judicial independence is meaningless. But these judges, Zinnes, Howell, Sykes, Pitts, Nunley, and others, are using their full authority. Contempt powers, discovery obligations, mandated releases, emergency restraining orders issued within hours. They're not afraid of being attacked as activists. They're not worried about the political blowback because they have lifetime appointments and constitutional authority. That's the whole point of judicial independence. And right now, it's the most important institutional check we have against authoritarianism. These court cases are part of a broader pattern of institutional resistance. Democratic state attorneys general filing lawsuits, sanctuary jurisdictions refusing to cooperate with ICE, immigration attorneys providing representation, advocacy organizations coordinating litigation strategies, and judges enforcing the rule of law. None of these institutions can stop Trump's immigration agenda alone, but together they create friction, delays, barriers, opportunities for people to organize, access legal help, and fight back. Every court order buys time. Every released detainee is someone who can stay with their family, keep their job, pursue their case with an attorney. Every precedent constrains future overreach. Every documented pattern of misconduct creates evidence for accountability. If not now, then later. This is how institutions resist authoritarianism, not through revolution, not through one dramatic confrontation, but through grinding, sustained use of legal authority to enforce constitutional limits. It's not cinematic. It's not satisfying in the way that mass protests or electoral victories are, but it's working. Judges are blocking policies, forcing releases, creating precedent, imposing consequences for defiance. The deportation machine is being slowed by judicial friction, not stopped, but slowed enough to matter. And that matters because the alternative is no resistance at all. The alternative is letting the administration detain people indefinitely, conduct warrantless arrests, deport people in defiance of court orders, all without consequence. The judiciary is saying, try that, and we'll hold you in contempt. We'll order releases. We'll require documentation. We'll certify nationwide classes. We have habeas corpus, due process, and contempt powers. Try us. And so far, when pushed, the administration is backing down or being forced to comply. That's not everything. but it's proof that institutions can constrain authoritarianism when they use their power. The question is whether they'll keep using it, whether judges will keep issuing aggressive orders, whether contempt findings will follow when orders are defied, whether higher courts will uphold these rulings. The fight is ongoing, but right now, federal judges are showing that the rule of law still has teeth, and people are walking free because of it.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.